is an appeal in the matter of Granville Technology Group Limited and others, and LG Display Co. Limited and others.
Yes, Mr. Raphael.
My lords, my lady, I appear on behalf of the appellants with Mr. Cookman, and my learned friend Mr. Musa is on behalf of the respondents with Miss O'Keefe. I will, if I may, start with three background matters. Firstly, the decision and the cartel.
So if you could keep your voice up a bit, that would help us all.
My lords, it's a persistent problem. I will do my best. I will start with three background matters. Firstly, the decision and the cartel. Secondly, the damages calculation. And thirdly, briefly, the tests for appeals. So to the decision and the cartel. The Commission's decision binds the respondents. That includes all findings which form the essential basis of or provide the necessary support for the determinations in the operative part or are necessary to interpret it. The judge explains that at paragraph 15. Other findings are highly persuasive evidence. The reference for that is Crean against Entrepreneur, 2006, UKHL 38, paragraph 6. We can provide that if required. The judge has found, non-exhaustively, that a large number of the recitals are binding, and he summarises them in paragraph 16 of his judgment. It may also be worth looking briefly at paragraph 4. So if I could ask you to turn up the core bundle, and you find the judge's judgment at paragraph 6, and you see it, paragraph 4, that in summary, the Commission found that all the defendants were participants in the cartel. The Commission found that the participants, including defendants, gave effect to the cartel by entering into agreements concerning future prices, price range to minimum prices, on pricing and commercial matters for specific accounts, on future production planning and future capacity utilisation, and by exchanging information on pricing, price coordination, and other commercial aspects. And then details of how this happened are set out in paragraph 16. I'm sure you've read that, so I won't take you through it, given the pressures on our time. The important point, though, is this is a serious, hardcore cartel. Indeed, the scope and range of the findings in the decision are extensive, cartelising the world market for liquid crystal display panels for 6 years. Now, Commission decisions don't make findings of quantum, so defendants in this position sometimes say that even though they infringed extensively, nevertheless, as it happens, fortunately for them, the cartel did not affect prices. However, in Royal Mail against DAF, the Court of Appeal has rejected that approach and held that the seriousness and extensiveness of the cartel's findings in a decision justify an inference that the overcharge is substantial and not minimal. If I could take you to that, that's in the Bundle of Authorities, tab 2, sorry, volume 2, tab 21.
Is this a legal principle, or is this just an application of the point that, as a matter of fact, you can assume that people wouldn't have done it in this way for so long unless they were getting a good reward from it? Is it a legal principle or just a factual?
It is a principle the court has adopted to the inherent plausibilities, which is systematic. I would suggest it goes beyond merely a case-by-case factual assessment. It's an indication of approach to be taken to cartels in general.
As a matter of law?
As a matter of law.
As a matter of I think you said volume 2, but in mine at any rate, tab 21 is in volume 4.
Ah, I think that's because I'm double-sided and you are single-sided, my lord.
Possibly.
I'll bear
Possibly
that
because all these cases are so long.
Yes, yes, indeed.
Paragraph 140.
Indeed. So, paragraph 140, on its admission, DAF participated in a secret cartel with other track manufacturers to maintain prices at a super competitive level for some 14 years. It is inconceivable it would have participated in the cartel such an extended period of time, all the financial, regulatory and reputational risks that entailed, unless it was gaining significant financial benefit from that participation. This was a point which the CAT correctly had well in mind.
Yeah, but that's, as I put to you, that's just a factual evaluation. It's just applying a bit of judicial nous. It's not a legal principle, is it?
Well, what I'll submit to you is when you look at the findings of the decision, exactly the same reasoning applies here. And that is therefore an inference that can and should be drawn on the basis of this decision. The seriousness of the cartel is actually still more apparent when you read the decision as a whole, and we've given you an indicative list of paragraphs in our letter last week. I'm not going to take you to the whole of the decision, given the time, but a couple of paragraphs are worth picking out essentially. The first is at paragraph recital 238 of the decision, which you will find in the supplemental bundle, tab 20. And this is one of the paragraphs the judge finds is essential and therefore binding. Paragraph 238, it's page 1266 of the supplemental bundle, tab 20. You see
1226.
1266. It can thus also be established, it's at the top of the paragraph, that the infringement had foreseeable, immediate, and substantial effect in the union in the sense of the Gencore case law, and then the details as to how this happened, and then finally the effect at the bottom of the paragraph, finally the effect of the agreement was substantial due to the seriousness of the infringement, its long duration, and the role of the parties on the European market. Also, if we turn to 304 of the decision, even though this is on page 1281, even though it's not necessary to show any anti-competitive effects, the facts as established in section 4, that's the long discussion of exactly what happened that precedes this, demonstrate the existence of anti-competitive effects of the cartel arrangements as a whole. And if we go on to 305 to 306, it's been demonstrated the undertaking involved directly and indirectly fixed prices and exchange commercially sensitive information. 306, there's also evidence of implementation of the anti-competitive agreements. And I'll spare you reading out the detail, but that's an important paragraph. Then if we move on to 330, based on the above this is page 1287, based on the above circumstances, it can therefore be established the cartel arrangements could and did have a substantial impact on the patterns of trade between member states and on the EEA market. Of course, we were then a member state. Now, the respondents may say to you that the market may have reached the same result as what the cartel had agreed by chance, by coincidence. But we'll submit to you that's an implausible proposition. So what that means is that an econometric model that produces the result that this cartel had no impact is implausible, inherently implausible, and actually lead you to question that model. Now,
But the respondents aren't saying that, are they?
Well, I'll
I mean, it did below, perhaps, but there's no cross appeal.
Well, may I take you to the significance of this point? It's actually quite a technical point on how Mr. Parker's model works.
Yeah?
So, on monitors, Mr. Parker's model produced a low overcharge of 5.7%, and the judge adjusted that up to 8%. However, on notebooks, that's laptops, Mr. Parker's model produced an overcharge that was statistically indistinguishable from zero. 2.4% was the model's central estimate, and the respondents therefore tactically conceded 2.4%, which the judge adjusted upwards to 4%. And that's the quantum that was found below. But that result was indistinguishable as a statistical matter from zero. And to explain that point, could I ask you to look at Mr. Parker's evidence in the supplemental bundle? And that's in tab 12 of the supplemental bundle, page 669. And This is Mr. Parker's, table 17 here is Mr. Parker's model. It's the model that in effect the judge accepted, but then made a couple of qualitative adjustments upwards, as you see. Now in this, and I'll come back to this in more detail, but in this model you have various outputs. The infringement indicator at the top is the one that gives you the cartel overcharge. There's a mathematical transformation that turns that into a percentage. Very roughly, you multiply that by 100. Against the outputs, you see stars. 3 stars, and this is explained in the note below, means statistically significant to a 1% threshold. That roughly means there is a 1% chance of the result being random within the assumptions of the model. 2 stars would mean statistically significant to a 5% threshold, and 1 star would mean statistically significant to a 10% threshold. No stars means no statistical significance, as accepted by statisticians. And the important point is that while the monitor output at the top, 0.0559, is 3-starred, the notebook output is 0-starred. And Mr. Parker accepts this point. If you go to paragraph 6.8 on page 667, you look at 6.8b. Below each of the estimated coefficients, I report the estimated standard error of the coefficient. That's the brackets on 669. This is a measure of the uncertainty that exists in relation to the estimated coefficient. The larger the standard error, the greater the degree of uncertainty. The standard errors and the associated concept of statistical significance are relevant to understanding the extent to which the measured effects are clear and systematic as compared to being due to statistical noise in the data. And then he explains the point I've just made to you about 1%, 5%, and 10%. And C, as noted in the guide of the European Commission and the judgment of the Court of Appeal in Britned, it's typical when conducting an econometric analysis to use a 5% threshold to determine whether an estimated coefficient is statistically distinguishable from 0. Just so you see it D before we move on. In addition, I report a number of transactions that include the analysis as well as a goodness of fit measure known as the within R squared, and that measures the proportion of the variation in the prices within panel units over time that can be explained through the regression through the changes in the variables included in the model. For example, a regression model within R squared of 50%, 0.5, is able to explain half of the variation in the variable of interest.
As I understand it, you try and get R squared as close to 1 as possible.
Yes, indeed.
So is another way of putting your point that the R squared value for the notebooks is less than 50?
That's another point I'm going to make. It's a separate point to statistical significance.
Okay.
Statistical significance is variability and precision of the data and the predictions you make. R squared is how much of the data's variability is explained by the regression. Now, just to pick up on the 0 point, if you go to 6.9 on page 669, you see at 6.9a2, the notebook panel, the estimated coefficient is not statistically distinguishable from 0. And then he says that the central estimate of the impact of the infringement was to decrease prices by 2.4%, and that the 95% confidence interval infringement effect ranges from -2.9 to 8.1, but there is no statistically reliable point within that. Now, what that means is that from Mr. Parker's own model, for notebooks, a cartel effect cannot reliably be seen. But in the light of Royal Mail, that is inherently implausible and calls into question his entire model. And that is not defeated by the tactical concession by LG.
But you don't appeal the judge's acceptance of Mr. Parker's model. You say he didn't adjust it enough, but you don't dispute that the judge was right to prefer it to your expert.
We say the judge was not wrong to choose as his primary initial indeed assessment of the relevant variables to input into the model, the ones that Mr. Parker selected. So that means, for example, the dispute in particular was the demand indicator was as to whether you choose semiconductor billings or whether you choose GDP growth. But what we say, and this is our ground 2C, is the judge failed to stand back, having taken that as the initial model, and test the robustness of that against other plausible models. And he should, when doing that, have borne in mind the statistical problems with Mr. Parker's model. That's our ground 2C.
What do you mean by other plausible models? Do you mean something other than a regression analysis?
No, other plausible models using the regression. What happened here was you had Mr. Parker's model,
Yes.
and then Dr. van der Laan said, well, there are problems with that potential variable. There are problems with this potential way of looking at it. Here's an alternative plausible model. And he produced a
Well,
range.
it's not an alternative model. He's just saying there are alternative variables.
I'm using that casually, perhaps. Alternative specification is perhaps the most correct way.
Okay.
And so Dr. van der Laan said, here's some alternative specifications. Your model, Mr. Parker, is not robust to small plausible changes. I'll come back to that. Consequently, even if you take your model as the initial starting point, other models need to be taken into account to give a reliable estimate of overcharge. So that's what we say on the ground 2C. That even if you don't reject Mr. Parker's specification, we're not saying you should reject the specification, it was wrong to accept the output of the model and then to infer overcharge from that without also taking into account alternative plausible models, alternative plausible specifications. I'll come back to that. And a central aspect of that ground of appeal is that when, let's imagine you have one model, one specification that produces perfect results, it is statistically perfect in all ways, then there's less force in considering in your overall estimate alternative models. But if your base model, even if it has the a priori correct variables, or better variables, and I'll come back to why these are not absolute, if your base model has obvious statistical defects, then it is all the more important to look, when you're assessing overcharge, at the alternative plausible models, even if their specifications are second best a priori. That, my lord, is the point. And the point here is that the decision is inherently inconsistent and in tension with the output of Mr. Parker's model. Now, the judge said, I can ignore that. I can ignore all considerations of plausibility. Under our robustness head, we say that was incorrect. Now, the second topic is the framework for the damages calculation. The defendants are jointly and severally liable for the entire impact of the cartel. Some settlements with other defendants partially satisfied that loss, and so credit needed to be given. The loss calculation methodology was common ground and depends on four variables: the volume of commerce, which is the amount of sales, amount of purchases, the overcharge percentage, and then volume of commerce times the overcharge percentage gives you the initial loss. Then you have the downstream pass-on percentage, which is the proportion of the price increase passed on, in fact, if that's proven to the relevant test. And finally, the lost sales calculation, because even to the extent there's being pass-on, the claimants will suffer a loss of profits because they lose sales as the price goes up, and this restores back a proportion of the reduction in damages that might otherwise be caused by downstream pass-on. This appeal concerns only two variables: overcharge and downstream pass-on. Now, there was an agreed spreadsheet into which all these variables got inputted, and the result was that the variables found by the judge led to a quantified loss caused by the cartel, including interest, of 4.4 million. That's recorded in the judge's order of 7th of February, which is in 1676 of the supplemental bundle you don't need to turn it up. After that, and post the judgment, which is why actually it's been a bit of time since the judgment, there were separate rulings debating the effect of the settlements. How much of the settlements are attributed to damages, how much to costs, and so how much credit needs to be given. There's no appeal on that. There was then a second agreed spreadsheet which inputted those variables and calculated the effect of the settlements. 1.6 million of settlements was allocated to damages. That affected interest. And that gave the net loss and interest, which is recorded in the court's order under appeal of 21st of October 2024, which is £942,000. If on this appeal you conclude that the overcharge or downstream pass-on percentages change, those can just be worked back into the spreadsheets. And there was no problem with that below. And so for that reason, we proceeded on the basis, it's in our appellant's notice, that once the court has decided the two variables, the calculations can be agreed. And so we have thus far spared the court the spreadsheets. But if the court would like to see them, or be provided with any illustrative calculations, that can be done. But in broad terms, just so you get a picture, a doubling of the overcharge percentage would increase the gross loss by double, and so on, but then the same flat settlement deduction would be made. So the increase in damages would be a bit over double. With regards to downstream pass-on, decreases in that will increase primary damages, but also decrease the lost sales claim, and there's mathematics there. But if the court finds that there's no proven downstream pass-on, which is our case before you, our primary case, the lost profits claim disappears. And mathematically then, the total gross loss would increase by about 31%, which we stated in our skeleton. And that, I hope, will give you a rough picture of how the variables you're asked to address would play out in terms of damages. Now, my third background topic is the law on appeals of fact. I doubt much will turn on this, but just you'll have seen what we've said in our supplemental skeleton. The short point is the test is that the judge must be plainly wrong. There's all sorts of case on this which you'll be well aware of. And language is often used that the result must be one which no reasonable judge could reach. We say that's focused on overall factual assessments. Henson, Foxworth and Supreme Court makes clear that it's sufficient to appeal on fact that, for example, it's in volume tab 5 of the bundle's authorities, but just to read out the relevant paragraph, which is 67, it's sufficient if a critical finding of fact has no basis in the evidence, or there's a demonstrable misunderstanding of relevant evidence, or a demonstrable failure to consider relevant evidence. And Klin and Lilly, which is in tab 14, para 86, explains it's sufficient if there's a gap in the logic or a failure to take into account some material factor which undermines the cogency of the conclusion. We say those criteria are sufficient. There's not some supra-added requirement to say the judge was irrational in making his clear error. So those are my background points, and I'll turn now to the appeal itself in three parts. Firstly, the ASDA point. Secondly, overcharge. Thirdly, downstream pass-on. Now, the ASDA issue. This arises out of paragraph 28 of the judgment, which I'll ask you to turn out. Now, the judge quotes Mr. Justice Popple and ASDA that the court should err on the side of undercompensation. Now, that's wrong. We all know that's wrong. The authorities are in our skeleton. The court must give the right amount of compensation without erring in either direction, which is Britned paragraph 65. That's in tab 11 of the bundle authorities. Now, in Britned, Mr. Justice Marcus Smith quoted ASDA, but then qualified it. That's what the Court of Appeal said at paragraph 59. The Court of Appeal thought that meant his judgment was not fundamentally flawed for that reason because of the qualification. It said that the reference was unfortunate. But even as qualified, they said they had to be alert to the possibility of the judge being unduly prone to giving the defendants the benefit of the doubt. That's Britnett.
Sorry, sorry. Are we trying to find a paragraph in Britnett?
That is paragraph 65 of Britnett.
Sorry, where is? Are we supposed to be looking at it, or are you?
I was just actually quoting it, but we can certainly look at it. So if we go to tab 11 of the bundle authorities, and it's paragraph 65 on page 825. Any suggestion, this is 65, in the case of present type, the court should err on the side of undercompensation is liable to give entirely wrong impression. Quite apart from the obvious point, the end of the court should be always to give the right amount of compensation or err in either direction. Then there's the point that his qualification saved it. But nevertheless, we should be alert to the possibility that he may be being unduly prone to give ABB the benefit of the doubt, or to err on the side of undercompensation when of necessity wielding the broad axe or broad brush. Now, there was a qualification in Britnett, there wasn't here in the judgment as written in the initial draft judgment. Now, the as the principle goes
Can you just help on what that means in a case, well, such as the present, I suppose, where the judge can only get so far with the evidence. So if we're talking about downstream pass-on, he's satisfied on the balance of probability that there was some downstream pass-on, but the evidence will only take him as far as something between 50 and 100%. And then he runs out of evidence with which to make firmer findings. So what is he then, on the Britnett approach, supposed to do? Does he go for the middle, 75%, because that, I suppose, narrows the possibility of being wrong, or does he go all the way or some of the way in one direction, either side of 75%? What's he supposed to do?
I'll come back to why his whole approach was wrong in terms of the test, but assuming you're in this position of making a assessment within a possible range, he should pick the right position, the most appropriate position that he believes on the evidence is justified within that range.
And how does he know?
Using judicial judgment rules.
What does that mean? Finger in the air?
Well, this is part of our essential point. The test is precisely to deal with this problem that you must prove a direct and proximate causal link to the downstream pass-on. That's the test which the judge failed to satisfy. And one of his problems was he ended up speculating.
All right. Well, in the case of the downstream pass-on, then you've got your arguments about direct and proximate link, and
yes,
no doubt we'll get to that. But if it's another issue, the amount of the overcharge, the evidence tells him that it is somewhere between 10 and 20%. But he can't be more precise than that. The evidence simply doesn't allow it. So he's got his axe out, but where does it come down?
It's never going to be as simple as 10 and 20. There will be indications as to what the 10 means, indications to what the 20 means. And he forms the best assessment, taking into account those 2 points. The problem he has created for himself, however, is that on that and on downstream pass-on, he's approaching all those assessments with erring on the side of undercompensation, dragging him down every step.
Well, I understand that, but there are cases where the evidence will only get you so far.
Yes.
You didn't like the downstream pass-on example because you want to bring in direct and proximate, and you say the judge got that wrong as well. So I tried to put a different example to you, and I don't think I've had an answer as to what is the judge supposed to do if he can be sure from the evidence that there was an overcharge and that it was not less than 10% and not more than 20%. But that's all the evidence can tell him.
In that situation, one appropriate response in the broad axe would be to take the 10 and the 20% points and choose some appropriate midpoint. That's what, indeed, the court did in Britnett. I'll take you to that. And that was upheld by the Court of Appeal.
I mean, do you take issue, or I'm not sure you can actually, but if you look at paragraph 60,
Yes.
this is a comment on what Mr. Justice Marcus Smith said in dealing with Mr. Justice Popperwell's statement. And they say what he obviously meant, as the whole of the passage which we've quoted shows, is that where the court is compelled to use a broad brush, it must still base its quantification on the evidence. And where reliance is placed on estimates or assumptions, it can't be assumed they will inevitably hold good. In other words, caution is needed when using estimates or assumptions, and although their use is fully justified when there is good reason for the absence of more precise evidence, allowance must also be made for the element of uncertainty which is inherent in them. My understanding is that the Court of Appeal said that's right.
The Court of Appeal said that was.
So
That was
understood
correct.
the judge's observations were in our view unobjectionable.
Yes, indeed.
You don't quibble with that.
Yes. But what you mustn't apply is a one-way bias when assessing uncertainty. That's the point.
Do you say that when we come to look at the judgment in particular points, one can actually see the judge's confirmation bias at any point? Or are you saying the mere fact of the Asda mistake should lead us to assume that at all points when he is picking a figure, he's got it wrong?
Both. If I can take you through the judgment. So the Asda principle goes right through the judgment and does so at each of the relevant assessments. So at paragraph 29, when talking about downstream pass-on, he refers to downstream pass-on, and then at paragraph 30, he says there's a difficulty about this issue in this case, however. In this case, there's very limited evidence, and the defence has sought to augment their case by expert analysis. This has added to complexity, and in my judgment, downstream pass-on approach in this way engaged precisely the same principles, plural, as those identified in paragraph 28 above.
It's not quite what I was asking you. I wasn't asking you whether he refers repeatedly to the principle, because he does, and you've given us all the references in your skeleton. What I was asking you was, when he comes to picking figures, can you say that we can see that confirmation bias at work in the maths?
You can see, yes, and I'll show you that. The point about principles is important, because if you go back to paragraph 28, you see at the bottom of it, he says he's arriving at the best estimate that can be achieved within the range, that's the broad axe, but applying the cautionary approach identified by Cockerill J when doing so. So whenever he refers to 28, whenever he refers to the cautionary principles, he's referring to both. He's referring to the broad axe as limited, as constrained downwards by Asda.
Although, just to take paragraph, play devil's advocate for a second, paragraph 30, the bit you just took us to, in the last sentence he says, well, so last couple of sentences, one, very limited evidence, two, that's undoubtedly added to the complexity and uncertainty of assessing damages, and that engages the same principles as identified in paragraph 28 above. Now, some of those principles, to the extent that they were reflected in that paragraph 60 I read out,
Yes.
are endorsed by the Court of Appeal, i.e., namely, where there is a lack of evidence and you augment it by the use of expert analysis, you've got uncertainty, and that's the court has to do the best it can. Those principles are perfectly legitimate.
Indeed, but the point is he's operating with two principles. He's operating with, and in a situation of uncertainty, he applies the broad axe and he constrains that by Asda. That is the very point. So,
I mean, I have to say I'm not at the moment as persuaded by that as paragraph 30, as perhaps there are a couple of other paragraphs which you...
there are others with a stronger, yes.
with a stronger point.
But when you really think...
emphasises my lady's point that rather than just taking a, quote, broad brush to this approach, we need to look with a bit more granularity about
Indeed.
exactly where this may have had an effect.
And I'll show you where it goes.
Well, you can make the point that in the footnote, he talks about the cautionary principle,
Yes.
and the cautionary principle which he is referring to there is the one which should no longer be followed.
Yes.
So when later in the judgment he refers to cautionary principles, it looks as if he may have in mind something which, at any rate, includes that.
Yes. The cautionary principle is ASDA. There's the broad brush, and there's ASDA, which is the cautionary principle.
Yes.
So moving on.
That all gets a bit confusing because in patent, the Court of Appeal say, well, you've got to exercise caution. Apparently that's different from the cautionary principle.
That's what he means.
In the jargon.
Indeed, what he means here. And then 31, you see again, this reinforces my interpretation of 30. Talking about the uncertainty, he says, in my judgment, it too necessarily engages the cautionary principles I've identified in paragraph 28 above. Then moving on from that, then you go to paragraph 84, and here's one of the specific examples that my lady asked for. Whilst I accept that ultimately the assessment overcharge involves a broad brush assessment applying the principle referred to in paragraph 28 above, that is largely for the purpose of addressing the problem created by the existence of a range of uncertainty concerning the percentage of price increase over the relevant period. The purpose of preferring multiple regression analyses is to reduce the area of uncertainty. And in looking at that uncertainty, he is explicitly factoring in the principles in paragraph 28. Then, if we move on to 107, he has discussed the variable, has picked the semiconductor billing variable as the best available proxy variable. Then he says, that said, plainly there's a risk that to a limited extent, the semiconductor proxy may underestimate overcharge by virtue of a limited endogenous element, allowing for that impact. This is his upwards adjustment he makes from the 5.7 to the 8 and the 2.4 to the 4, require the application of the principle summarised in paragraph 28. So there's a very concrete example. When he does his adjustment, he's factoring in ASDA. Then, if we go to 143, we get to the upwards adjustments.
But hold on, there his adjustment at 107 is to increase the overcharge, and therefore increase the likely damages.
He was forced to do that by the deficiencies he found. The point is that the adjustment he made was constrained downwards, you'll see this, by ASDA. It would have been higher, but for ASDA. The evidence said I've got to make an adjustment. He makes one, but it's lower than it would be. And you see at paragraph 143, applying the principles summarised in 28 above, and taking account of the endogeneity risk posed by the use of the semiconductor proxy, leads me to conclude, and also in combination with the uncertainty noted concerning the effect of post-cartel price persistence, leads me to conclude that if I was to adopt Mr. Parker's figure, that would underestimate to a limited degree the level of overcharge. In my view, a modest, that's quite an important word, adjustment upwards is required to eliminate the possibility of under-recovery by reference to source uncertainty, but limited so as to take account of what I consider to be likely to be the modest effect of both factors and the need to be cautious to avoid overcompensation. He puts it the other way around there, that is a one-way bias, and actually what he's bearing in mind all throughout is the principles he's articulated centrally in ASDA. If we turn to downstream pass-on, then there's paragraph 226. And this comes back to the point that you put to me, my lord. He's having assessed the nature of the evidence. Given the nature of the evidence relevant to the downstream pass-on issue, I consider the approach summarised in paragraph 28 above, so that's both principles, is one I must apply to the downstream pass-on issue. And then he goes on to uncertainties. And that just reiterates that when he's assessing those uncertainties, he has ASDA firmly in the centre of his mind. And then we go on to 246, and this is where he reaches his conclusions on downstream pass-on. As I've set out in paragraph 28 above, the assessment of damage in competition infringement cases is likely to involve estimation and approximation to arrive at an appropriate figure in the bounds of uncertainty established by the evidence. It involves the application of a broad brush or broad axe. As always, there are two factors in play. The need, on the one hand, to ensure that a claimant has compensated for infringement, but to err on the side of undercompensation where there's uncertainty. So at every stage, he essentially has a double principle in mind, not just the broad axe. And that paragraph 246 explains what he means throughout. And then you get to his actual conclusion on downstream pass-on, which is where he picks a figure. In relation, this is 247, in relation to this issue I'm now considering, this allows the narrowing of the range of uncertainty concerning downstream pass-on that mentioned above, that's between 50 and 100. In my judgment, applying the principles summarised in 28 above, taking out the whole of the expert and other evidence relevant to this issue, that pass-on is likely to alter over time, and he gets to his figure of 65%. But he's applying the principles in 28 above.
If paragraph 247 had stood alone and without 246, would you have a leg to stand on?
Yes,
because the wording in 247, the requirement to exercise caution where there is uncertainty, precisely reflects the paragraph 60 that I put to you in the authority, doesn't it?
It's the reference to paragraph 28 above. In his mind, in contrast to in Britned, he's not applying the market of Britned qualification.
But the principle from paragraph 28, which he extracted and seemingly applied at the end of paragraph 247, was simply a need to ensure claimants are properly compensated against the requirement to exercise caution where there is uncertainty. Now that is, I think, an accurate summation of that paragraph 60 of the Court of Appeal judgment. It says nothing about the erring on the side of undercompensation. So the point I was trying to put to you was that I can see your point in relation to 246, but if 247 stood alone, would you really have much to complain about?
Yes, because ASDA is saying that the caution he's applying is one way. That is the problem.
But the Court of Appeal said in that paragraph 60 that there was a requirement to exercise caution where there was uncertainty.
Yes, indeed. But not a systematically biased caution. That's the problem. And it's quite clear what he has in mind when you look at it throughout.
But what is the judge's thinking here? Because I can understand he's narrowed the uncertainty to somewhere between 50 to 100%, and that's the best that he can do. Now, if he were to follow the approach of saying, well, he could have, start again. He could have said, well, I'll split the difference and call it 75% because whatever figure I'm likely to take could well be wrong. But if I go to the midpoint, then that will minimise the possible effect of any error I might make in either direction. But in fact, he picks 65%, which is a more favourable figure for you than the midpoint. So it looks as if he is erring at all, he is erring in favour of something which risks overcompensating more than it risks undercompensating, which is contrary to what he's said in paragraph 28. So can you suggest what his thinking was in getting to the figure he got to?
So this comes back to my point that he's not just picking an average. What he's doing is within ranges, he's assessing the evidence he's got. And there were strong factors here against downstream pass-on, which he acknowledged. In particular, he acknowledged the effect of psychological pricing, and to a more limited extent, he acknowledged the effect of extended warranties, and there were other factors he referred to and accepted militated against psychological pricing, against pass-on. He also acknowledged that chunks of the evidence pointed against pass-on. And so what he's doing is, in this range, he's bearing in mind the evidence that pushes him to a lower figure. But we say that ASDA has led him to go at a higher point than he otherwise would have. Well, the points are similar in relation to lost.
Before we move on,
Yes.
where he refers to a blended rate, is that something which reflected a discussion of evidence from the experts as to different approaches that might be taken? Because he's also got reference at 272 to a blended margin figure. And
I wouldn't go.
I just wanted to make sure, because we're very aware that we don't see everything.
No. The blended margin is something totally different. That's on the lost sales calculation. You can ignore that. Blended rate, no. What happened in this case was Mr. Parker was contending for 100% or very high. Our evidence in our case was there was no direct and proximate causal link to any pass-on. There wasn't a blended rate put forward by experts. That's the judge's figure, and actually it picks up the point I've just made to you. He's blending the factors that militate against pass-on with the factors that militate, he thinks, for pass-on, and then he picks a figure, but in doing so, ASDA is driving him at every stage.
Isn't it more simpler that he's talking about the fact that there are different products, there are different prices prevailing at different times, that the extent of pass-on may not have been consistent all the time, and he just picks a figure of 65% as representing the best he can get, taking account of all of that. Surely he's taken account of things like psychological pricing and extended warranties and so forth in getting to the 50 to 100%.
No, it's also the 65 model, it must be. The 50 to 100 is an abstract prediction of economic theory, which he doesn't actually hold good. He gets to 65% by factoring in the key factor, actually, which pushes him downwards, is psychological pricing. Now, Lord's turning to the...
Sorry, as I understand it, sort of to focus on this, but as I understand it, he gets to 50 to 100% on the basis of the evidence. That's what he says at the beginning of 247.
The economic theory, yes.
Okay, evidence as to economic theory. Or expert evidence. He then exercises caution because there is uncertainty, and he assesses the pass-on at 65%, which is favourable to your client, in the sense it's on your client's side of the halfway line, if I can put it that way.
Yes, but he's identified some very strong factors against psychological pricing, so it's an illusion to think this is erring in our favour.
Okay, so where do you say he should have been?
Well, our case very simply is there was no case found at all, and I'll come back to the test.
That's a different point.
Fails.
Assume you lose on that point. Where should he have gone in a number?
Well, that's a difficult proposition to put to me. May I reflect on that while I come back to it? Simply because we don't accept there's any case here at all, and all the factors militate against sufficiently to defeat.
But does that mean if you lose on that point, we leave it at 65% then?
No.
So would you like to tell us which number you would pick?
Could I come back on that? I will, because I'm going to go
It's
through.
not difficult. I mean, you've got 15 to choose from, haven't you?
Well, if you're accepting a 50 starting point, it would be 50.
Well, do you accept 50 as
We
a
do
starting
not,
point?
no.
No, but if you're wrong on your first point,
Shall we say 25? That's a very unsystematic figure. I'll come back to why. I'll come back to all the points which actually explain what's going on here. But in the judge's world, he is going to a higher figure than he otherwise would because of that.
And one of the issues which we may or may not have to face is what happens if you win on ground 1 but not on grounds 2 and 3, and that puts us in a difficult position because I don't see how we can do the exercise. And you would say there's no point in sending it back to the judge because he's already had a go at it and said it makes no difference. So it will put him in an impossible position if he's told he's got to do it again. So what in those circumstances would we be supposed to do? We will, in due course, need your help on that.
Well, just to give, I don't want to take too much time on this right now. We have quite a lot to get through. But on the specific point of the upwards adjustments, we have given you some precise figures in our supplemental skeleton. I hadn't given you a precise figure on downstream pass-on yet, because all the complexities of doing that. But on the upward adjustment, we have given you one. That's in our supplemental skeleton. Now, just picking up, we don't really need to look at the lost sales calculation because we're not appealing on that. But he does again refer to ASDA. The paragraph 254, just to make a correction to our letter of yesterday, you see that the adjustment proposed is excessive and should not be adopted having regard to the quantum. In this area, a court should err on the side of caution in order to avoid overcompensation. See the authorities referred to paragraph 28 above, and that's a reference to the authorities. We identified to you in our letter that the words "in order to avoid overcompensation" were blue and were additions. That was slightly wrong. In fact, what he added at the draft judgment stage is "to avoid overcompensation." "In order" was in his draft judgment. So it actually read "in order" and then the dash, which was a slip. Just, I don't think it matters, but just for accuracy, that's what I want to correct. So LG's response is that the key variables are binary matters of logic, which ASDA wouldn't influence. And we don't accept that. We say that all these assessments involve questions of judgment, which are not binary and are capable of being, were influenced by ASDA. ASDA affected him generally and also on multiple particular disputed points into which he built one-way biases. The way I propose to address that is to go through the primary appeals on the variables, and then I'll illustrate it as I go through. So that takes me to ground 2 on overcharge. And I'll explain first the basics of how this works. Now, there are various ways of estimating overcharge. None of them are perfect. The crudest way is you just draw a line in a price graph between the point where the cartel starts and the point where the cartel finishes. And anything above that, that gives you an estimate of your cartel overcharge. That's obviously crude because it doesn't account for the fact that the market might have moved upwards or downwards in that period for other reasons as well. Dr. Van Laan here did a trend line extrapolation, which, as his primary case, he had the alternative case on the models, and the judge rejected the trend line extrapolation. Now, the point of regression models is they can be used to deal with these other changes in price. And these models are explained in the Commission's practical guide on quantification, which is in the authorities bundle, tab 26.
Do you know which authorities bundle that is?
For you, my lord, it'll probably be...
Can I just go, sorry,
Yes.
can I just go back to something, and I'm sorry to have just not caught up with you quickly enough, but the letter, it's going back to paragraph 254.
Ah, yes.
I'm just trying to understand the point you made about what the judge actually did to paragraph 254.
Well, I'm very grateful because I realise I've missed a bit of my note, which I need to deal with.
Yeah.
So can we roll back to ASDA? Because, of course, the judge did do a correction.
Well, what as I understand it, just can we be clear, if you go to 254,
Yeah.
The fourth line says, given the nature of the third line, given the nature of the problem identified and should not be adopted, having regard to the requirement that in this area a court should err on the side of caution in order to avoid overcompensation.
Yes.
And you say that is the reference to in order to avoid overcompensation is in fact wrongly including the ASDA
Yes.
thing. But if I understood your letter correctly,
Yes.
the judge didn't actually have those words in order to avoid overcompensation in his draft in the first place at all. He just said, and should not be adopted having regard to the requirement that in this area a court should err on the side of caution. Now, if he'd have left it alone,
Well, the answer is there's other points where he talks about in order to avoid overcompensation.
yeah, but I thought the point you were going to make in reliance on the letter is that the judge has actually made it worse by the correction he made rather than better?
I don't place particular reliance on 254, my lords, because it's not part of the appeal. We're not saying that variable should change.
Okay.
The simple point is, and it really is simple, is as a psychological human reality, he was approaching everything in the light of erring on the side of undercompensation, and the exact tweaks in the language don't really matter. The reality is simple.
Okay.
But what I did miss before I went on to regression is the judge's correction. I do need to address that. So,
I suppose it depends how the erring on the side of undercompensation manifests itself, whether it manifests as part of the process or whether it's only when you're scratching your head and going, which way do I jump between figure A and figure B? Because if it is the former, then that's essentially the point you're making. If it is the latter, then we need to look for the points where the judge says, okay, I've got these two figures. And you can then say that he's erring on the side of undercompensation.
I'll come back through the judgment. I can't deal with everything, but I will come back to specific elements. But on the footnote, so you'll have seen that in our note we brought the matter to the judge's attention, as was appropriate, and the judge then responds by putting in footnote 1. Now, he in this, he firstly says that he didn't make any conscious adjustments applying ASDA. But with respect, that doesn't deal with the problem. ASDA articulated in this way has embedded itself in the preconceptions with which he approaches each issue. And it's simply not humanly possible or psychological reality to separate its effect from its absence. We don't judge the judge's good faith at all, but the subconscious human reality is it will have affected each of his assessments. And it's striking that Lord Justice Phillips said when granting permission that nevertheless the judge didn't remove ASDA from his judgment, and that the footnote remains incoherent and includes the one-way bias of avoiding overcompensation. And then finally the footnote...
You may say complaint, wouldn't you, if he'd simply taken the reference to ASDA out and left the judgment unaltered? You'd have thought, well, there's a bit of sleight of hand going on here.
That's a counterfactual world, my lady. And then finally the footnote says the judge has reperformed each of his assessments and concludes that no adjustments are required. And again, we don't doubt his good faith. But the subconscious human reality is that with this note arriving 2000 on a Friday, the second draft judgment early in the afternoon on the Tuesday, it's simply not possible with a judgment of this complexity, with this number of assessments, these amounts of issues, to reconsider everything from the ground up in less than 2 working days without confirmation bias. So that's what as the point, and my apologies for taking that slightly out of order. And now if I can come back to regression. So I was taking you to how regression models work. And these are explained in the Commission's practical guide on quantification, which is in tab 26 of the authorities bundle. And I think you'll find it in volume 4. And then at 1913 is where I'd like to start. I'll have to take this relatively briefly. So regression analysis. 69. Regression analysis is a statistical technique which helps to investigate patterns in the relation between economic variables and to measure to what extent a certain variable interest, here price, is influenced by the infringement, as well as by other variables that are not affected by the infringement. Regression analysis therefore makes it possible to assess whether and by how much factors other than the infringement have contributed to the difference between the value of the variable of interest observed on the market during the infringement period and the value observed in the comparator market, or during a comparator time period. That's 69. And then into 70. In a regression analysis, number of observations for the variable of interest and the likely variables are examined by means of statistical techniques. The relation identified is described in the form of an equation, referred to as a regression equation. This equation makes it possible to estimate the effects of including variables on the variable of interest and to isolate them from the effects of the infringement. regression analysis estimates how closely the relevant variables correlate with each other, which may, in some instances, be suggestive of causal influence. And then 69, provided this is consistent with a coherent economic framework. That's a point that was stressed by the judge. Now, there are then two main approaches, and just summarising that, you can do a forecasting approach, which is not what was done here, or you do a dummy variable approach. And in a dummy variable approach, you have an equation which on the left-hand side has the variable of interest, price, and on the right-hand side, you have the explanatory variables, costs, demand, capacity, and an infringement indicator. And it's that infringement indicator that converts into the overcharge assessment. Then moving on to 75, you see the following graph gives a simple illustration of how such a relationship is deduced. It's possible to calculate the coordinates of the line that best fits all data observations in order to represent a statistical relationship. That's correlation. Relationship is expressed in the graph below as a line and can be usually also expressed as an equation. Here we're working with an equation, but the graph gives you the idea. Then 78. And this is something the judge focused on. When undertaking a regression analysis, it's important to consider all variables that are relevant in the specific case. 79. The basis of each damages quantification using regression analysis is thus the statistical relationship between the variable of interest, price, and the relevant explanatory variables expressed in a regression equation. And you see then more detailed explanation of the dummy variable approach in footnote 77. Then paragraph 80, you see an example of the approach with the dotted line in the graph in 79 is the counterfactual, black line is the actual, and you see the dotted line outside the in 80, outside the infringement period is derived from the regression equation and can serve, through comparison with the actually observed non-infringement prices, to assess the predictive power of the regression model. Now, obviously, to be satisfactory, your regression must explain the data. It must be a good match, otherwise it's useless. So you're not just specifying variables and then blindly applying them. The resulting equation has to fit. If it doesn't, you then need to interrogate your variables. And so there are various statistical techniques to test that. And you've seen from what the Commission says about how the passage I'm taking to you that the model has to fit the data. Paragraph 85, you see it should be stressed that even very sophisticated regression equations rely on a range of assumptions and will, like any technique, only be able to deliver estimates. It's good practice to consider the assumptions underlying a regression equation, because some assumptions may be more appropriate than others in a given situation and may lead to significantly different results. The judge explained this in 43 to 45 of his judgment. You're looking for proxies to create your model, and they're proxies of how the economy is going to develop in relation to the specific market. And here, the proxies what people were looking for were proxies to explain the effect of costs, the effect of demand, and the effect of capacity. Now, those proxies are imperfect. This case illustrates that, because the judge had to use semiconductor billings as the proxy for demand. Now, he accepted he couldn't use data for liquid crystal display screen demand itself. That's because that would be endogenous. It's affected by the variable you're seeking to predict, and so statistically it just cannot be done. You have to use a variable that's not endogenous. But the problem then is that semiconductor billings, though the best variable, as the judge found, is flawed because it's at a distance from the relevant market. And just for your note, before we leave this, 87, you see the Commission stressing the importance of statistical significance as a way of testing. So that's the Commission. And then there's also 3 judgments that explain how.
When you say semiconductor billings, can you just unpack that a little bit? What exactly were these numbers derived from?
There was a data series, semiconductor sales on the worldwide market for semiconductors.
And that's a proxy for demand.
Demand for LCD screens. The idea being that if people are buying lots of semiconductors, they're likely to be buying lots of screens as well. Because chips are parts of computers and computers need screens. But it's not a...
So semiconductors, what, just for computers or just semiconductors generally?
The whole worldwide semiconductor market as a proxy for demand.
And because it's the whole worldwide market for semiconductors for any application.
Yes.
Hence your comment that it's some distance from the actual LCD panel market that we were looking at.
Yes, indeed. And this goes back to my point that though Mr. Parker's model had the right variables, the best variables, it is a fragile model. That goes to my robustness ground of appeal and why you should look at other indications as well. That's the very point. 3 judgments also address key elements of how this works. The first is Royal Mail and DAF in tab 19 of the authorities bundle. First, we go to 328. So there's discussion of how regression works.
Sorry, which tab?
Tab 19, my lord, 1193.
1193.
Am I right that 2 of your ladyships are working with the computer and 1 is working with hard copy?
Yes.
Then
The authorities bundle is 1 page out of sync
Ah,
with PDF. But that's a manageable disparity.
I'm grateful. I'm sorry about that. Then, turning to 329, you see the output from the regression model is an equation that estimates the relation between the dependent and independent variables in the form of estimation coefficient. Dependent variable is price, independent variables are cost, demand, supply. The model also generates numerous other outputs. For example, it will show the statistical significance of the estimated coefficient, how confident one can be there's a measurable correlation, and a measure called the R-squared, which defines how much of the observed variability in the dependent variable is explained by the independent explanatory variables. Then you have then a discussion of coefficient transformation in 330. I'll come back to this, but essentially you have in these models, you saw it in Mr. Parker's, you have these coefficient numbers that are spat out. And for the explanatory variables, in short, you can view those as percentages. A 1 unit change in the explanatory variable, so 1 unit change in semiconductor billings, if you then have 0.5 written as the coefficient, that correlates to a 0.5% increase in price. 1 unit to the percent that the coefficient represents. You see that at 330 written in. Then 332, you see the specification of regression models involves a very large number of choices. These choices have considerable effects on the coefficients. We deal with key disagreements below, but they arise from a number of common and well-known difficulties with multiple regression estimation, including, with various problems, but in particular, omitted variable bias, where important variables are omitted that might explain movements in a dependent variable, which are omitted from the model, and this will obviously affect the quality of the estimate. And there was evidence here that Mr. Parker's model had an omitted variable problem. Now, the next case to look at is BritNed, which is in the Bundle Authorities tab 7. Paragraph 290, which you find page 551. 290, there's a general discussion which I won't take you to all now. Regression analysis starts at 290 sub 4, the bottom of page 551. If we then turn to page 552, you see in 5, heading 5, considering the reliability, you see that statistical significance is a way of testing whether results obtained are due to a coincidence or whether they reflect a genuine relationship. And then at 297, you see again a discussion of R squared. And taking this briefly, I apologise for the brevity of some of the references I'm having to make. You see, essentially R squared is the square of explained variation over total variation. That's the point I've already made. And then the relevance of statistical significance and how it works is picked up at 303 to 305 in terms similar to what I've already explained to you. The final case to look at is Stellantis and Autoliv. And this is at, these two are, this is judgment of the cat, and this is at tab 22 of the bundle of authorities. So you see paragraph 184 is discussing the point we've already seen about.
We have a page, please.
1452. Paragraph 184 is discussing the point we've already seen about dummies and how the coefficients work. 185 is discussing the coefficients. Just to make this point, I've already told you that on the explanatory variables, the coefficients are 1 unit to the equivalent percentage change. It's a bit different from the infringement indicator. That you multiply by 100. So 0.05, which you saw in Mr. Parker's model, is a 5% overcharge. And that's because you're making it a percentage of 1. Then 186 is again is a useful discussion of standard errors and significance. Now, 187 is the key point I want to take from this. It should also be kept in mind that the standard error and the level of statistical significance are calculated on the basis that the model itself is an accurate representation of reality. Since any model is at best an approximate representation of reality, the standard errors and claim levels of significance must be treated with caution. It is therefore common practice to test a model by seeing how the results stand up to reasonable changes in assumptions. Now, that is a point which was common ground on the expert evidence. It's the core of our robustness ground of appeal, but it's a point the judge ignored. And later in Autoliv, at 214 to 215, the models were rejected because they were not robust to plausible changes in input. The point being, you know these variables are imperfect. If you have a model which spits out result X on the basis of specifications A, B, and C, and you make some small, plausible change to A, and it produces a totally different result, or a largely different result, even if your initial specification of A was the a priori best one, the fact that a small plausible change drastically changes the output should lead you to question the reliability of the estimate you get from the initial specification. That is the key point the judge missed, and it's at the heart of ground 2C. Just to make the point that is a standard point.
So you mentioned the reference there, Autoliv. What was that? You said, I thought.
It's in.
It's 186 Autoliv at tab 22 of the bundle of authorities. 187 on page 1453.
And then it was paragraphs 214 and onwards for
an application.
By reference.
So in the same case. Sorry, I thought you were referring to a different case.
No, it's the same case. 215, the same case. And just to show you that this principle was standard and accepted by both experts. First, to Parker's second report in Supplemental Bundle 1, tab 13, 901. A35, a good model should be robust in the sense that small changes to the data used
Sorry, where have you gone to? You've gone to supplementary
bundle tab 13, page 901. My lords. A good model should be robust in the sense that small changes to the data used should not lead to large changes in modelled outputs. And the same point is made by Dr. van der Laan in his second report, paragraphs 1.2.12 and 1.2.13, Supplemental 1, tab 8, 415 to 416, and that was not challenged in cross-examination. Well, that's robustness in a narrow sense. Then that leads you to statistical testing. There are various ways of doing that. One is R squared. You've seen that. It's a measure of goodness of fit. It explains the proportion of the observed dependent variable, price, that explained by the independent variables. And that again was common ground. You've seen that from Mr. Parker, Parker 1, 6.8d, Supplemental 1, 112, page 668. So a model with an R squared of 50% explains half the variation in the variable of interest over time. And Mr. Parker accepted that a significant change in R squared is an indicator of the superiority of a model. Parker 1, 6.25, Supplemental 1, tab 12, page 82. Now the judge addressed this at paragraph 48. To be a little bit more precise, R squared is equal to 1 minus the square of all the variations in the data from the predicted line, divided by the square of the variations in all the data from the mean. So it gives you a measure of the proportion of the data which is explained by the regression. And I should mention one refinement, which is the difference between R squared and adjusted R squared. One problem with R squared, again this was common ground between the experts, was you can improve R squared sometimes simply by specifying an extra variable, because there's more variables in the equation, it explains more data. So you may not be comparing like with like if you just chuck in more variables. But there is a test that meets that problem. It's called adjusted R squared, which includes a correction for the number of variables. And that's van der Laan 5, paragraphs 1.53 to 1.54, Supplemental Bundle 1, tab 11, 544, which again was not challenged in cross-examination.
Supplemental Bundle 11.
Page 544. There will be a transcript, my lords, for references. The other standard test is Ramsey reset. This identifies whether there's an omitted variable.
Just to be clear, what we're doing at the moment is this is a teach-in.
It's a teach-in.
Rather than making any points at the moment.
It's a teach-in and I'm then going to make my point.
Yeah, okay.
Because otherwise we can't get anywhere.
Yeah, no, I'm grateful for it. Sorry, I was just checking I'm not missing a point
No.
you're making. No, right.
I mean, obviously I'll put in little points as I go along, but it is a teach-in. Now, this identifies whether there's an omitted variable. It's explained by the European Commission in the decision, Annex 2, Supplemental Bundle, tab 22, page 1335. One standard test usually performed to check the quality of estimation is the Ramsey test for omitted variable bias. The Ramsey test fails. It's very likely that at least one variable which should have been included in the model was instead omitted, leading to biased estimates of the coefficients, the direction of the bias being unknown. Now, as the final bit of the teaching, it's just going back to the models to see how this works. So the first is Mr. Parker's, which I've already shown you. It's Supplement Fund Bundle, tab 12, page 669. Now, that's the model. Just to go back, if you go back to 666, I won't take you through the detail. There he explains what his variables are. For demand, he's using changes in the average of semiconductor revenue, 6.6C. For capacity, he's using the quarterly change in glass substrate industry capacity. Glass substrate is what you make these panels from. And then cost is B. Those are his explanatory variables. And then you see that in 6.669. And so you have the monitor notebook values, and so costs, using the metric I've given you, a 1% increase in the costs variable gives you roughly a 0.8% increase in price. Demand shock, 1 unit, because that's not logarithmic, increase in semiconductor billings gives you a 0.5% increase in price. Supply, your 1 unit increase in the supply variable gives you a minus 0.5% decrease. It's negatively signed because capacity and price are inversely related.
So I've lost where you are.
I'm sorry, 669. If you look at the monitor figures.
Page 669.
Yes. So you see the logarithm of the cost, the demand shock, and the supply shock. Those are your explanatory variables. With a 0.806, the 0.0592, and the 0.539 figures. You got me so far.
Yep.
And so, for example, what that is saying is that a 1 unit increase in the capacity metric gives you a minus 0.5% decrease in price, because capacity and price are negatively related. And those are all statistically significant to 3 stars. And then the monitors, you see that's what gives Mr. Parker's infringement indicator. That you multiply by 100, not the straight percentage, and so it becomes 5.5%. That multiplication is slightly inaccurate. There's detailed maths agreed by the experts. It becomes the 5.7, which the judge adjusts to 8. And notebooks, the 0.02.4 becomes the 2.4%, which the judge adjusts to 4. That's how that model works. But just now looking at this model, the points about even if your variables are the a priori correct ones, there are problems with this model. Firstly, notebook result is not statistically significant. And secondly, R squared is low. It explains 70% of the data for monitors, but the notebook side of it explains less than half. Just while you're there, the bracketed figures below, those are the standard errors. That's an estimate of the precision of the data, and that feeds into the statistical significance calculation. Now, that's Mr. Parker's model, and it's worth looking, then, at the last bit of this teaching, the most important contrasting model. To make this point, you will have seen in tab 19 of the bundles a regression aid memoir. Now, I'm working with that as a colour A3. Would it help if you had the colour A3 loose as well, or are you happy to proceed with the bundle?
Well, if you've got it,
We do.
let's have it.
Certainly, I find it extremely useful, not least because my eyes aren't as good as once they were.
You will give us the bundle reference.
It is. It's tab 19.
Thank you very much.
Bundle reference to this, where you'll find it, is tab 19, page 1188. And it can also be done usefully on the computer. Now, what this aid memoir does is it takes all the data from all the various models that were done to test the robustness of Mr. Parker's model and gives you the main outputs. And Mr. Parker's model is in the top left. So you see 5.7% for monitors, 2.4% for notebooks, 3 stars for monitors that are dashed, that means no statistical significance for notebooks, and then you see the R-squareds. MNT monitors, NTB notebooks. Then I'll take you back to the other models here when we go, or some of them, when we go to robustness.
Can I just
Yes.
check the status of the aid memoir?
It was a document which summarises all the data in the models in the bundles, which Dr. van der Laan then confirmed was accurate in examination in chief, and it was not said to him it was inaccurate. My learned friends say there's some data in here which isn't in here on other details. That's true, it couldn't have everything, but it's not said that anything in this is false. So it's a ready recorder, but an accurate one, of the models. And the primary model which we rely on underground 2A, the price lag model, is at the bottom left. It is the model with 30.1% overcharge for monitors, 21.7% overcharge for notebooks. You will see it is statistically significant at 3 stars for both outputs, and you will see it has significantly higher R-squared for both, 0.84, 0.74. So that, you will see that, and I will look at some of the other models on this to illustrate our robustness point in due course. But for now, we need to look at that model in the bottom left. And that you find in Supplemental Bundle 9, page 509. And this table,
Supplemental 5.
Supplemental tab 9, page 509. And this reports what happens when you take Mr. Parker's model and include price lags, which are ground 2A. I'll explain what price lags are. That means you are not just looking at the price in period 1, you're looking at the prices in period 1 affecting period 2, 2 affecting period 3, and so on. You model the effect of price persistence. Now, in this, columns 1 and 3 are Mr. Parker's model.
So you treat there, just so we get the terminology right, you just treated price lag and price persistence as 2 sides of the same coin.
They are, yes.
So you say that it takes time for changes in price charged for an LCD display to a manufacturer to be reflected in the price that the manufacturer charges for the finished goods?
It is a statistical relationship. It is saying that the price in period 2 is in part statistically explained by the price in period 1 and not just costs, demand and supply. Now there are various explanations for that. One is prices take time to change, but there are others. The statistical point is there is price persistence. Price is not just a function of explanatory variables as a statistical matter. It is also in part a function of previous pricing. And there are lots of reasons why that might be so. One is price smoothing. You when you wish to feed in prices, you don't change prices, you don't feed in the change immediately. Another is that when you decide on...
help.
Yes.
Come more slowly. When you say when you, can you be specific about who's doing what to the prices?
The cartelists. The people who are selling LCD screens.
So is the point this, that in January, the cartelists put their prices up to their buyers, but it takes their buyers a time, perhaps until February or March, to put up their prices to the claimants, or is it more sophisticated?
It's nothing to do with the buyers. It is...
Well, who are the people then?
It is the pricing of the cartelists in the market, and it is saying that that price is persistent in the sense that it does not reflect simply underlying costs, underlying demand, but also responds to the previous prices of the cartelists. Their prices are persistent. They are affected by previous pricing. To give you an illustration of that, let's imagine a world where there's only one, a monopolist, forget the cartelists. And the monopolist, in each period, just says, well, here's my costs, here's demand, I'm going to set prices at X. In that situation, there would be no causal relationship between previous pricing and future pricing. But if the cartelist, when setting his prices, also says, oh, and my price last month was X, and that's part of my decision-making process, then you have price persistence, and that is modelled by price lags.
So is this price persistence a sort of reflection of the desire not to be shopping and changing prices all the time? Is that one factor?
One factor. It's also that it takes time for changes in costs to be reflected in pricing. It may take time simply to change your menu of costs. If you're a cartelist, you may not wish to go up to 100 straight away. You may wish to feed things through over time. There are numerous explanations for the intuition behind price persistence. But one is simply smoothing, another is time taken to change, another is responses to demand and costs, taking time to feed through. But it is a statistical relationship saying that part of the explanation for prices in period 2 includes what prices were in period 1. That is the essence. And you model that by putting a price lag in the model. One other explanation for it, there's lots of explanations, is long-term contracts. If you have the cartelist has not just I will sell spot each month to a computer manufacturer, let's say Dell, but rather has a long-term
contract with fixed prices.
With fixed prices or with prices that are changed quarterly or something. That's another reason why you'll have price persistence. It means that the price in February is not just affected by whatever may have happened on demand, costs and supply in February. It means that your previous pricing has a long-run effect. The pricing in itself, because that's embedded in the long-term contract. But that's one among many explanations of price persistence. Now, price persistence modelling is standard, common. Whether it exists in a particular market is dependent on the evidence. We say there is evidence of it here. So, coming back to this. Is there anything I need help you with?
No, keep going.
Coming back to this model, Mr. Parker's model is in columns 1 and 3. Then for monitors and notebooks respectively, that's just the same data you've already seen. And then the bottom left model is in columns 2 and 4 for monitors and notebooks. And it's taking the same data, the same explanatory variables that Mr. Parker used, but it is simply including a modelling factor to lag prices, so they are affected by previous prices. And with that one change, that plausible change, you end up with a, firstly, much higher overcharge. You see that at the top, 30.1, 21.7. Just so you know, in lagged price models like this, the calculation I've given you of multiplying by 100 to get the overcharge doesn't work because the effect feeds through over time and you need an extra transformation. And so that's why your figures of 0.549 become 30.1%. That transformation is common ground, and I'll give you the references in a moment. So that's the transformation. But not only does it produce much higher overcharge, it has much superior R squared. You see, if you go towards the bottom, R squared, and that's 0.848 for model 2, 0.740 for notebooks. And also, there is a difference on Ramsey reset, because the red is fail, the green is pass, and Mr. Parker's model always fails. Including price lags, there's a fail for notebooks on the price lag model, but it passes on monitors. Now that's...
Can you just...
Yes.
Can you explain to me why including a lag of a month, which as I understand it, what the first line of the table is, leads to such a large increase in the overcharge?
It's a lag of 3 months that's included. You see, there's 3 months for notebooks and 2 months for monitors.
One month is the table above, isn't it?
No,
that
so
right?
the model has 2 months, and that gives you 2 indicators, 0.54, let's say column 2, 0.549 and 0.268. Those are the impacts of the lag of price, and then the infringement indicator is then 0.0550. So what that is saying is there is a correlation based on the lag of price.
So you're saying that this adjustment is done on the basis of a 3-month lag?
3 months for notebooks, 2 months for monitors, because that reflects the data.
Why is it in the 1 month row?
Sorry, what are we looking at here? If you look, monitor 2, log minus 1 month, that's the 1 month lag, 0.549, 2 months lag, 0.268.
Yeah.
And then for notebooks, there's a 0.197 for the 3 month lag. That's column 4.
So is this table testing whether what would be the effect of prices lagging by 1 month, 2 months, or 3 months?
Yes. If you assume that there is evidence of price persistence for 1 and 2 months for monitors, 1 to 3 months for notebooks, and you put that into your equation, you specify your equation so the equation works with a price lag, that is what those models produce.
Right, so that, if I've got this right, so that you told us this is all to do with the cartelists.
Yeah.
The cartelists don't change their prices, is this right? For 1, 2, or 3 months, or that there is
An effect.
an effect of
Relation.
previous prices by the 1, 2, or 3 months, so that the changes are slower to come about than if they did it immediately.
That's part of it, but not the whole of it. It's simply a relationship. There is a relationship between price, but you're not simply explaining price in period 3 by reference to demand and supply in period 3.
Okay.
Rather, it is a part of the system.
What I'm trying to get my head around is why that persistence, for whatever reason it is, but for something other than supply, demand, etc., creates such a big difference in terms of the overcharge percentage.
You've created an equation.
Well, I know you feed into a model and a sausage machine and a number comes out, but in the real world, can you explain to me why?
Well, you're starting from the wrong assumption, if I may.
Okay.
You're starting from the assumption that Mr. Parker's model is reliable. Because actually, what we're actually saying is a correctly specified model includes price persistence, and the overcharge it produces is that figure.
Yes, I know you are. But I'm asking you why, including the lag, as you say, should have been done, that there is price persistence at the cartellist's level produces a much bigger overcharge?
There is no reason. It explains the data. That is the simple point. When you model with that price lag, the data is better explained, and then you ask yourself, well, now I know what the right line is, the right line through the data points. You then ask yourself what the infringement indicator is.
Yeah,
It's not the price persistence causes overcharge to be higher. No. It is simply a fact that the data is better explained by the price persistence model. And then, once you know that, you then tell yourself what the infringement indicator is. All that is, you are just seeing Mr. Parker's model is wrong. That's all you're saying.
But you want us on this appeal, as I understand it, to say that instead of an overcharge, and overcharge equals compensation damages.
Yes, that's right.
You say it shouldn't have been 5.7%, it should have been 30%.
Yes.
So you get
More money.
more money. Okay. And that's on the basis that your clients, you say, must have overpaid for these products by a greater amount.
Yes.
Right. I'm just trying to get my head around why persistence in the cartellist's behaviour meant that you would have paid so much more.
It doesn't. You're asking the wrong question there, my lord, because there's no relationship. A price persistence model could produce lower overcharge. It could produce higher. It could produce 15%. There is no reason why modelling for price persistence produces higher overcharge at all. You are simply asking yourself, using this dummy variable approach, what is the model that best fits the data? What is the model that best explains the counterfactual economy without the cartel? And therefore, by putting the infringement indicator, you then get to explain the observed data. You are simply finding the right model. If there is price persistence, you should model for it, because that is the way you will get the model that best reflects the economy. So it is not the price persistence leads to higher overcharge at all. That would be a conceptual error. It is that price persistence is the best way of modelling the counterfactual, and therefore once you've modelled the counterfactual, you then estimate the overcharge based on the model. That is the point. And if putting in price lags led to a lower overcharge, which is quite possible, because that's simply what explains the model data, then that would be the correct figure if price persistence is the reality. And this is
So it is economic theory that tells you that price persistence is a thing. Is that right? Rather than evidence which shows you that price persistence was happening in our case.
Well, Mr. Parker just assumed static variables in his model, and without an evidential basis. Actually, here there is the explanation I've given you, the economic theory explanations, but there is also data. There is evidence to prove price persistence, both statistical evidence and qualitative evidence. I'll come on to that. And one of the things we say the judge got wrong is he failed to consider that evidence. In fact, he found there was price persistence in one part of his judgment, but ignored that when doing the regression, and that's his fundamental error on ground to it. So that's this model. And there's one final technical point. I'm going rather slower than I'd hoped. I will try to speed up, but if you'll bear with me if I sometimes take things quicker than you'd like. And this is this. If you look at the coefficients in models 2 and 4, that is, as you've seen, the percentage change in price that correlates to a 1 unit change in the explanatory variable, you will see that they are, in absolute terms, smaller than the coefficients in Mr. Parker's model. So to look in column 2, look at semiconductor revenues, it's 0.0592 for Mr. Parker, 0.0109 for the price lag model.
Sorry, where were you reading?
Semiconductor revenues. Changing 3-month moving average of semiconductor revenue.
Right.
0.0592 in Mr. Parker's model, column 1. 0.0109 in column 2. So it's about 5 times less as an absolute figure in column 2. Do you see that? Maybe the confusion is because it reads across to the moving. So you read from the word moving, you then see the figure. So you see it's a small absolute figure. Now,
Sorry, what's the conclusion?
the point is this.
From
A point is made by the judge that he thinks it's implausible that you'd have a significantly lesser effect of, let's take demand, semiconductor revenues, in the price lag models. He thinks that 0.109 is a much smaller figure, and that is a reason against adopting models 2 and 4. But that is an illusion, because in price lag models, because effects feed over time, that 0.109 gives you only the single period static effect, and coefficients in a lagged model need to be transformed to give you the long run effect. That is called a scaling factor, and again, that transformation is common ground.
Can I just make sure that I'm in the right place in your skeleton? Are we 31C?
Probably. Yes, that's explained. And the references to how this transformation are done, it's common ground. It's in Parker 4, paragraph 2.3.1, Supplement and Bundle, tab 16, 1062. It's in Van Laan 5, 1.3.9, 1.3.11, Supplemental Bundle, tab 11, 540 to 5. Pages 540 to 541. And when you do that transformation to get to the long run figures, this discrepancy, difference, disappears. And my apologies for the detail, but it is important to understand this. So if we go to Van Laan 3, table Van Laan 5, which is in tab 11 of the supplemental bundle, and you go to paragraph 1.3.9 on page 40, you see he calculates the long run.
So what's the bundle reference?
540, I think.
Page 540.
540.
And he calculates the long run coefficients. And when you go to the long run coefficients, he gives them in 1.39A to C for monitors and the 1.311 for notebooks. And there you don't have a major difference. You have for cost coefficients, 0.81 for Mr. Parker, 0.64 for the lag model. The demand, it's 0.06 and 0.06. For supply, it's 0.54 and 0.27. And nobody suggests that that level of comparison is telling against the lag price model. Because, of course, there's no superiority to Mr. Parker's figures. The data has just told you that is the percentage relationship. It is not the case that simply having a difference, a greater size, is superior. The point the judge made, and the point Mr. Parker made, was that a very big difference indicates that costs and demand aren't really explaining anything. And that was said to be implausible, but that point was a false one because it was made on the basis of the short-run coefficient comparison, comparing comparing short run to short run, which is comparing apples and pears when you're comparing dynamic models. And
So can you explain short run and long run? What's going on in the real world? I mean, in a sense, I'm struggling here. I'm struggling to relate the difference in numbers, coefficients, and the like with what they represent in the real world.
so your intuition is this. Let's take demand. That in the Parker model, it tells you that a 1 billion, a change of a billion in semiconductor revenues, a change in that figure, produces a 0.05% increase in LCD prices. That's the correlation the Parker model tells you. And that tells you there's an impact of a correlation between semiconductor revenues and LCD pricing. That's the intuition there. When you're modeling the economy, you can understand it by using semiconductors, and that is the percentage correlation.
Lots of people are buying semiconductors. Ergo, it's thought lots of people will will want LCD monitors. Is that the thought process that's going on?
When you're buying PCs, you're buying LCD screens, and you're also buying semiconductors.
Yeah, so you
correlation.
say semiconductor revenues in the world at large have gone up. More people are buying semiconductors.
That is correlated to
And that's used as a
demand
proxy for demand for
LCD screens.
LCD screens.
Yes.
Okay, so I understand that.
And
What
Mr.
does
Parker's,
that do to price?
you are modelling the economy, you're modelling the effects on price of demand, cost, and capacity.
Right.
And you put the variables into your model, you specify a line, and then that gives you the coefficients of the relationship between the two variables.
Okay.
And the point the judge makes is, when I look at the coefficients in the lag price model, they are much lower than the coefficients in Mr. Parker's model, which tells me that the relationship between semiconductor billings or capacity is much less. And I think that is implausible. But he has looked at a model figure which only gives you, in the context of a lag price models, the one period change, not the total change. And the common ground is that to give you the total change, you have to do the transformation. And the explanation of that, which is not challenged in cross-examination, was Van Laan 5, 1.37, 1.312, bundle, supplement bundle 11,540. Therefore, if you want to understand in the lag price model what its coefficients mean, the total impact, the total relationship, the correlation of price, of demand to price, or cost to price, or capacity to price, is given by looking at the long-run complete effect, not just the partial period effect, in a model that necessarily works over periods, multiple periods of time. It's a simple statistical fact about how you read the coefficients on dynamic models, lag models.
Is it a simple statistical fact per se, or does it have an interrelationship with the nature of the cycle you're talking about?
I'm sorry, I didn't catch that many.
Is it a simple statistical relationship per se, or does that have a relationship to the nature of the cycle you're talking about? So the kind of economic cycle you're talking about for the particular item in question?
So when assessing different models, one thing you will ask yourself is price persistence plausible in this market? And there's nothing to be drawn from just a difference in size, 0.6 compared to 0.1. That reflects what the statistical relationship is in this market as the data shows. But the point the judge made is if you've got a major difference, 0.1 compared to 0.5, 6 times, he suggested that meant, well, I can see that there's really not much relationship between demand and price. And he regarded that as implausible. This is 115 of his judgment. But that effect disappears when you compare not just one period of the lag model, but the whole of the lag model by doing the transformation.
But the point I'm asking you about is the whole transformation period, because I think the point that was made against you was that it appeared to be predicated on a long cycle to work through fully into the price.
Yes.
18 to 24 months or something.
That's a separate point which I will come on to. Yes.
Yeah.
Yes, that is a point that's made against me, and I'll explain that in due course. They say there's a specific reason not to choose price persistence in the context of what's called the crystal cycle. I will come on to that. So that then is the statistical teaching. And I'll now turn, if I may, to ground 2A on price persistence. And the question is, was there evidence of price persistence, and should the judge therefore have adopted the 30.1, 21.7 model with lag prices? Or should he at least have taken that model into account as an additional indicator which you infer in the broad axe overcharge? Now, including time lags of variables, including price, is standard. With apologies, I'll just give you a reference to that. That's Van Laan 5, 1.315, 1.318, supplemental bundle, tab 11, 541, where he refers to a textbook, a Nieberding textbook, explaining some standards. And that was not challenged in cross-examination. We also have...
When you say it's standard, does that mean because it's standard because it bears some resemblance to the real world, namely that prices don't change instantaneously?
Yeah, that's part of the explanation, yes. Because it is a common feature of markets that you see price persistence, because the economic explanation is a rational one. So it is standard, not universal, but it is very, very common to use price lags in modelling of cartels just like this.
Because price persistence is a feature of most markets in which cartelists operate?
Well, I can't make that proposition good, that it's a feature of most cartel markets. I have no evidence to support that. I can
when
simply...
you say standard, I mean, it suggests that in most cases where you're trying to model the effect of a cartel on a market, whatever the market is.
That number is more than I can tell you. I'm saying it is a common, routine, standard in that sense, way of doing it. I can't say 50%. There's no assessment of that.
No, I wasn't asking for a number. I was just saying the theory is it in the standard case, a market will exhibit price persistence?
I don't have...
What do you mean by standard, I think, is what I'm really getting at there.
Well, shall I just take you to the passage then? It's probably easiest. If one goes to page 541 of the supplemental bundle, and I'll make the point good. I'll start with Nieberding. So what Mr. Van Laan, Dr. Van Laan says, and he wasn't challenged on this, the inclusion of lag price variables is common practice. This is 1.315 on page 541. Common practice is how he puts it.
That's a bit less than standard.
And then Nieberding says there may be evidence that price unstudied does not adjust instantaneously to change the market conditions, because even after control for contemporaneous and exogenous market factors, current price may still depend on past prices. One method of capturing such price dynamics is to allow for the presence of a lag-dependent variable. That's the
So explaining it in normal language, saying that in a particular market that you are looking at for the purpose of determining the effect of cartelist behaviour, it's at least possible that prices don't respond instantly to changes in cartelist behaviour.
No, in response to underlying variables like cost, demand, and capacity.
So the cartelists don't change their behaviour instantaneously?
In response to such variables. They may be, you can have price persistence even if a cartelist responds immediately, can act quickly if, when doing so, his prices are impacted by prices in previous periods.
What it seems to me to be saying is not that it's standard, but that the first thing you're looking for is whether there is evidence
Yes.
in the particular market.
Indeed.
And if you find that there is, then one way of dealing with that is to allow for lagging.
Indeed. And
Is that a fair summary in slightly more common language?
There's the common practice point. But may I take you to the other two sources I'm going to take you to?
Okay.
So,
but to pick up my Lord's point, the last sentence of 1.3.15,
yep.
he says the inclusion of lagged LCD prices in the model I present in Vanderlaan 3 addresses the fact that LCD prices do not adjust instantaneously to changes in LCD market conditions even after controlling for cost, demand and supply factors. Yes. He's presenting there as a fact. I think Lord's sort of saying, well, okay, is that based on evidence?
Yes, it is. There's separate evidence, which I'll come to.
Right.
That's right. And the judge accepted that evidence. That's the key point. Now, on this, if you go to page 1382 of the supplemental bundle, there were there's parallel US litigation in which there's lots of experts who've given evidence.
Sorry, I missed the reference, please.
1382 is the page reference, and the tab is 30.
Actually, as you've been
Tab 31.
kind enough to supply all these volumes, it would help also to have the volume reference.
I'm sorry, because I'm working with a different
I
volume.
think I've got it now. Well, if I could have the reference to the bundles I've been given, is all I'm really asking for.
I will try and... Now, may I ask where your volume 2 starts, your volume 3 starts, your volume 4 starts?
The one we're at the moment, volume 4, starts on 21.
So volume 4?
2 starts on 8.
Yep.
3 starts on 14. And 5 seems to start on something orange.
Well, I'll try to work with those. Then there were experts in the parallel US litigation of the same cartel, and we've given you passages of the reports of those experts, very distinguished professors, both for a defendant and for a claimant, which is the relevant point. Professor Bernheim and Professor Carlton. And at 1382, paragraph 94, you see Professor Bernheim saying, including lag prices is common practice in the time series forecasting literature. The leading textbook states the following, that, and this is the bottom, lag-dependent variables can dramatically enhance forecasting performance. And Professor Bernheim says that it's generally more reliable to have lagging in 95. And then if you go back to 1378, to tab 31.
Sorry, actually, the paragraph 93 at 1381 is
Yes.
sort of quite vaguely informative.
Yes.
I use my words carefully, because it actually attempts to give some sort of explanation of, that I was searching for as to what's going on.
Yes. I mean, it's not surprising Professor Bernheim explains it better than I do. And then that was Professor Bernheim, and then Professor Carlton, the other side, is at 1378. paragraph 244, he says that the use of lag prices is important to capture the evolution of prices. Now, the economic explanations, the common causal patterns that can explain price persistence are well known. You've seen what Professor Bernheim says about them. They can include time taken to react to changes in costs and demand, current uncertainty as to what may be going on with costs and demand, so a delay in response. They can include enterprises judging their price for the future using their current price as a yardstick, which is very commonplace. They can include smoothing price changes to avoid shocks to customers. You want to go to 100, but you don't do that straight away. And it can include pricing by reference to customer expectations based on previous pricing. And it's entirely unsurprising that you're going to have price persistence in many markets. And then the key point, there was also clear evidence that there was price persistence here, and the judge accepted that evidence at a different point in the judgment. Now, I'm going to address issues in three parts. Firstly, finding of price persistence and why it cross-applies and should be used in the regression. Secondly, the judge's subsidiary reasons for rejecting price lagging. And thirdly, the defendant's viewpoints.
Price persistence can go either way.
In
the sense that, as I understand it, you say price persistence is a reflection of the fact that cartelists may fix their prices by reference to prices in previous months.
Yes.
So this could be that if, for example, they decided for some reason they just wanted to increase the price relying on the cartel, that they wouldn't just do it instantaneously. They might want to smooth it so it wasn't so detectable.
That's part of it. That's one of many explanations.
And on the other hand, if there's a cartel and there's an external fall in, say, for example, the cost of raw material, they would, instead of that feeding straight through into the market in a cartel situation, the market wouldn't, the cartelists would be able to fail to pass on that saving for a while because they're in a cartel.
Yeah.
I mean, so it could go, is that right? So
Absolutely.
It could go up or down.
Yes, it will, in a cycling market, it will elongate both troughs and crests.
Yeah, what I'm just trying to do, I'm afraid it's obvious to everybody, but I'm just trying to understand how the econometric models that you're running us through relate to cartel behaviour in the real world.
First of all, an important point. We are not modelling the cartel. We are modelling the counterfactual. Because you know what
what would have happened in,
and so you're actually modelling absent the cartel. So the actual proposition is that there is price persistence absent the cartel. That is the proposition. And if you have a monopolist, in your situation, yes, and we all see this with energy prices. Some change happens on the worldwide market for energy prices, but do the energy companies drop their prices to customers immediately? No, they don't, because they wish to make money. And one thing they will do is persist in previous pricing before they drop. Price persistence expresses completely obvious economic rationales in various dimensions, both upwards and downwards, in a non-cartelised market. Of course, there is price persistence in cartels as well, and cartels can create that, but we are not modelling for that. We know the actual prices. We are modelling for the difference between the actual and the counterfactual, and so we are asking ourselves, is there price persistence in the counterfactual without the cartel? That is the question.
But the answer would be it could still result in an upwards, or it could be price persistence up or down in the non-cartelist situation.
I mean, if you imagine your curve, imagine you have a cycle with a capacity problem, prices going up, and then capacity comes in, and prices would, but for price persistence, just shoot down. Price persistence will flatten it, will make the curve less steep. Or it means that whatever the price is at a particular period, that is more likely to continue as an additional factor on top of demand, cost and supply. And there's lots of reasons why that can be so. And I've given you some of them. And the reasons that you've identified are one of the main explanations, but not the only one. And you've seen that also in Professor Bernard. So that's the economic rationale. Now, but of course, if there's no evidence of price persistence, then one wouldn't model for it. And, or at least you might assume it and then test against the model, but certainly your case for modelling for it would be much weaker if there's no evidence. Now, what has the judge done here? So if you go to his finding is at paragraphs 133 to 137 in Core Bundle 98. Now, before I take you to that, it is vital to understand the history. The history is that Mr. Parker, initially in his first report, accepted the validity of price persistence as a possible modelling choice in principle. He rejected 1 month price lags only, just 1 month, because they produced statistically odd results within his model. That's Parker 1, paragraphs 6.27 to 6.28, supplemental bundle tab 12, so I think that should be in your volume 2, my lord, page 684. Then, in Van der Laan 2, Dr. Van der Laan produced evidence of significant price persistence derived from Mr. Parker's data. That's Van der Laan 2, 4.34 to 4.39, supplemental bundle 8, which again should be in volume 2, page 438 to 439. Now, his evidence identified some relationship up to 9 months, but a much stronger relationship up to 2 or 3 months. Now, at that time, he was not... I'll show you that evidence in a moment.
Okay, and was the evidence talking about price persistence generally, or was it talking about price persistence after the cartel was presumed to come to an end?
It was, well, just if you look at page 134, paragraph 134 of the judgment, you see the graph. The data set that we were working with is, because it was LG's data, it's from January 2001 to October 2006. And the price persistence identification was in that whole data set over that whole period. And that is including the cartel period, but also before and after. Because the cartel starts in October 2001 and then takes a bit of time to have an impact. And it stops in February 2006. So the data Dr. Van der Laan was working was before, during, and after. Now, at that time, Dr. Van der Laan was not using this for regression. He was using it for an explanation of why the post-cartel data, post-cartel prices, were influenced by the cartel even after the cartel had ended, because of price persistence. That was one of Dr. Van der Laan's reasons why Mr. Parker's model understated overcharge.
And when you say the cartel had ended, do you mean it had factually ended because they'd all been found out, or was it the period that was fixed as the cartel period by the Commission?
By the Commission. And so there is a degree of ambiguity as to what happened afterwards.
So
we have to proceed on the basis that it finished when the Commission say it did, because this is simply a follow-on action, and you haven't sought to prove that there was cartel activity on the 1st of February 2006. I can see that the effect of the cartel during the Commission period could continue.
There's a slight nuance on that, in that Dr. Van der Laan said, well, the cartel is proven up to February 2006, but there may have been some conduct afterwards, and you'll see that in the data. But for present purposes, another more concrete explanation of the cartel still having an impact after February 2006 was the price persistence information.
Yes.
And Dr. Van der Laan modelled for price persistence.
I mean, we have to assume, don't we, that all the cartelists woke up on the 1st of February with a change of heart.
I think you can't necessarily assume that we are not claiming damages for anything they may have done after February 2006. That's the short point for our purposes. We only say they're bound by a cartel after February.
Yeah.
Then, in the joint memorandum, Mr. Parker accepted this evidence of price persistence up to 3 months, but rejected it beyond 3 months. That's paragraph 20 in the joint memorandum, supplemental bundle, tab 17 in volume 3, page 114. And when he did that, he was accepting the reality of price persistence, not just as a statistical artifact. Dr. Van der Laan then took the price persistence evidence and worked it into the regression model to produce the lag model you see. That's Van der Laan 3, 1.18, 1.31, supplemental bundle, tab 9 in volume 2, page 506.
I'm so sorry, Mr. Raphael, I lost the last two references. So the joint statement and then the one you just given us.
Supplement, we will have a transcript, but I'll,
No,
indeed,
I'd like.
indeed, of course. Supplemental bundle, tab 17, page 114 for the joint memorandum.
No, it starts
No.
on 1081.
That's,
and it
that's
might be
why I
one,
was getting
it might be,
confused.
it might be 1140, but it's not 114, that's for sure.
Well, I am very sorry. That must be a false reference. It will be,
What paragraph? Of the
it's
joint
paragraph
statement?
20 of the joint memorandum, which is what, 1114.
Triple.
I'm sorry.
Thank you.
Now, the reason I'm not taking to these documents is because the judge makes findings about them, so you just got the story. Dr. Van der Laan then worked that persistence into Mr. Parker's model. I've given you the reference to Van der Laan 3, and that's supplemental bundle 9, page 506. That then caused Mr. Parker to seek to resile from his acceptance of the evidence of price persistence, which he'd given in the memorandum. The judge did not accept that, and that's in the judgment in the discussion at 133 to 137. And so 134 shows the graph. Dr. Van der Laan shows the prices used is persistent, by which he means the present price depends at least in part on the price in previous time periods. That's the,
In the joint memorandum,
yes.
Mr. Parker is dealing, as I understand it, with price persistence in the real world after the end of the cartel. Now, why does that read over into acceptance of price persistent in the counterfactual world during the cartel?
Firstly, that's not what the judge found. I'll show you that in a moment. But just to look at what Mr. Parker
Well, have I understood correctly what Mr. Parker is actually accepting?
the judge makes findings. Can I show you what the judge found as to what Mr. Parker was accepting? Then I'll come back to Mr. Parker.
Okay.
So, Dr. Van der Laan carried out an analysis of the material which led him to conclude that
Sorry, we're
134,
134 of the judgment.
yes, which led him to conclude that Monte price, when tested against any particular price result, results in lags 1, 2, 7, and 9 months, and for notebooks 1, 2, 3, and 6 months. Dr. Van der Laan says this means in real world terms the price for a Monte panel is partly determined by the price in the previous month, and then the other months.
And just to be clear, what's the graph got to do with it?
The graph is the actual price data.
Yeah. Well, how does that help you determine whether there's price persistence?
Oh, he's done a mathematical calculation that works, assesses price persistence within that data.
Okay, I'm not really helped by the graph though. I don't understand. The graph just shows what prices are, but why does it tell me how price persistence?
The graph does not give you the underlying equations for the price persistence.
But why is the graph there at all?
Oh, because the graph shows, this is important for other purposes, that the data being used is before, during, and after. That's what it shows.
All right.
Dr. Van Laan summarises evidence in the joint memorandum as being that the price of an LCD panel in a month is partly determined by the price of the LCD panel in the previous month. Mr. Parker's response, this is my Lord Justice Mell's point, I do not consider that Dr. Van Laan has demonstrated price sensitivity for 9 months. His analysis shows effects for months 1 and 2, but no significant effect on months in months 3, 4, 5, 6, or 8. For notebook prices, Dr. Van Laan finds significant effects in months 1, 2, and 3. That's the lagged months, but after that, a mix of insignificant, incorrectly signed lags. I would therefore consider Dr. Van Laan's analysis consistent with price for at most 2-3 months. So he, like Dr. Van Laan, is analysing the whole data set and saying that across that whole data set, he accepts lags of 1 to 2 months for monitors and lags of 1 to 3 months for notebooks. That is what he's accepting. He's not just talking about the post-cartel period, he's talking about the whole data set, which has been analysed. Now, we've spared you the underlying mathematics because that's what's found. Indeed, I think we don't actually have, because Mr. Parker accepted this, we don't actually have all the underlying statistical mathematics. The output is in some very detailed annex somewhere, but it was accepted.
I mean, so I'm struggling with this. I mean, because the introduction to these paragraphs is talking about the effect of in the post-cartel period.
Well, that's the point I'm making to you. The evidence is the evidence. It was used at this point initially, when you wrote the memo, to demonstrate effects post the cartel period. Because if there's price persistence as a feature of the market, one thing that will do is that the cartel has an effect post the cartel. But that is not because you're only modelling for the effect of the cartel post the cartel. It's because you modelled for price persistence and found it as a feature of the whole data set throughout, before the end of the cartel, before the cartel itself, during the cartel. That is what has happened. I don't think that's disputed. So, then, when this issue was explored in cross-examination, Mr. Parker changed his evidence. He didn't say this is only about the post-cartel period. He tried to say that there was just a statistical correlation in prices over the whole data set. You see this at 136. In other words, Mr. Parker's oral evidence was closely opposite of what he was apparently saying in the joint memorandum. As he added in the course of answer to cross-examination, it doesn't mean there's an economic mean to that correlation. It doesn't mean it's actually determinative prices. It means you're picking up a statistical correlation. He never said, oh, and this is only for February 2006 onwards. It just simply wasn't what anybody was saying. This change of position is unsatisfactory. Mr. Parker is a highly accomplished economist with very substantial experience of giving advice and evidence in competition. This change struck me at the time he gave his oral evidence and strikes me as a substantial change of view that require a clear explanation of how the error came to be made and substantial justification for I could safely accept it. I was not satisfied then, I'm not satisfied on either aspect. I conclude that inherent properties are as Dr. Van Laan said. So he has accepted the evidence of price persistence in the model, which goes all the way before, during, and after. Now, at this point in his reasoning, he is considering only this overhang point. That's how he then goes on to apply price persistence. But the finding is a finding that Van Laan is correct, and that there was price persistence reliably modelled in the data up to 3 months for notebooks and up to 2 months for monitors.
Sorry, you're going to have to keep your voice up, I'm sorry.
So he is, at this point in his judgment, he relies on the finding of price persistence for for the overhang issue, post-cartel effect.
Yeah.
But the finding is a finding of price persistence modelled in the data and as not just a statistical correlation but a real effect, and that throughout the whole period of the data, which goes all the way back to 2001. That's what his finding is.
And that finding, which obviously is important to you, is in the first half of the sentence, which says, I conclude in paragraph 137.
Yes.
Is that it?
That's right. That's exactly right. And then he goes on to say, and that means I don't accept Dr. Parker on the overhang point.
So you read the and as disjunctive.
It's a separate and additional point. And then, just to 138, that said, I don't think the past post-cartel price effects are capable of calculation with precision by reference to the statistical analysis that Dr. Van Laan has used. Particularly, I do accept that analysis strongly supports the inherent improbability the effects of the cartel came to an end at midnight on the 1st of February.
So to put it sort of simply as I'm getting it, you're saying, look, the judge has found here that on the evidence there was there would have been price persistence, there was price persistence after the termination of the cartel. That's based on the fact that there is price persistence across the entire data set.
Yes.
So when you're looking to model the position that would have applied absent the cartel, you should be doing so on the basis of price persistence.
Exactly. That's exactly right. So, Lord, I see the time.
Yes.
But there is a developing problem, which maybe I should anticipate this. I am running behind time. I don't know how much as yet, and I will try to accelerate. It's a function partly of the questions from the court, of course. It's also a function of my false estimation. I am doing my best.
Well, I'm afraid the position is we've got 2.5 days set aside for it. You've given us a timetable. You can speak faster if you want, but it means we'll understand less as you go, so that's not really going to help you. Some of this is quite complex material. Well, I think we've got to the nub of your point on down to today.
May I just understand whether there's no possibility of using the half day?
We'll think about that.
No, I'm blind.
All right, 2 o'clock.
For rise of April